Well, thanks very much, everybody. I feel like I'm the meat in the sandwich of the MWU New South Wales problems. So today I just wanted to commence by acknowledging the traditional owners of the land on which we meet and to pay my respects to their elders past, present and emerging. Today I'm going to be looking at the new environmental protection laws that will come into force in Victoria next year on the 1st of July, and really just highlighting some of the impacts on the waste industry and some tips for getting ready for the changes. So the new laws are going to introduce a really fundamental change in approach for environmental protection in Victoria and really move the regulatory framework from a reactive, offence-based framework to a more preventative regime. And so these changes came out of quite an extensive review of the EPA. There'd been a number of issues identified with Victoria's environmental protection laws and the way that they were being enforced. So there was an independent inquiry in 2016, and the Victorian government responded to that in 2017, accepting nearly all of the changes and recommendations of the inquiry. So there's been two pieces of legislation passed, and just to really explain how they work, the first was the Environment Protection Act 2017, which commenced last year. And that Act made some changes to modernise the EPA itself, so it's more about how the EPA is structured. It clarified that the purpose of the EPA is not only to protect the environment but also human health. I think it had been doing that, but it really clarified that that was part of its objectives. And since then we've seen a lot of resources go to the EPA. I heard that from sort of in the last 2 years there's been the number of staff has gone from 450 to 600, lots of new enforcement officers, and really the appointment of a scientist to head up the science part of the organisation. So it's really gone through some change. Then last year we had the Environment Protection Amendment Act 2018, and that's what I'm going to talk about today, and that contains all of the substantive provisions that will be the new laws. And so when that comes into force on the 1st of July next year, that will create the new Environment Protection Act of 2017, and the current 1970 Act will fall away. So at the moment we're operating under both the 2017 and 1970 Act. So at the moment, the EPA and DELP are just about to release the regulations which underpin the framework, and there'll be consultations being undertaken for the rest of this year with, as I said, an expected commencement date 1 July 2020. So the key themes for the new legislation are up on the slide there, and as I've mentioned, prevention is really the big one. Also, the regime is intended to provide a much more flexible framework for the EPA to work with, and also taking a much more risk-based approach. There's also a focus on provision of information and transparency and access to justice, and as I mentioned, modernising the EPA. So really the change of approach will change the kind of question that the EPA will be asking of business, from whether a pollution event has occurred to what are the systems and processes that your business has in place to eliminate or reduce risks to human health and the environment. So the new provisions have been very specifically modelled on the work health and safety legislation, which has a very general approach to providing a safe system of work. And reflecting that is really the fundamental new duty that is introduced into the Victorian laws, which is a general environmental duty. Now, some of you in the room might be quite familiar with the general environmental duty. It is in place in various other states. But significant is that in the new Victorian laws, this will be an offence provision, both where the EPA will be able to choose whether to take criminal prosecution or a civil penalty action in the courts. So, for example, in Queensland, there is a general environmental duty in the legislation, but it's used as a defence to other offences. So Victoria moves it one step forward in terms of it being an offence provision. So the duty applies in relation to all activities and to all Victorians. And it's interesting to note also that the duty applies upstream. So the duty will apply to all persons who design, manufacture, install or supply substances, plant, equipment or structures. So that considerably widens the scope of the duty. So it's not only, for example, in the waste industry, those that are undertaking waste collection, treatment, recycling activities. It will also apply to those that are supplying equipment and plant to the industry. And so that general environmental duty needs to be met for all designers, manufacturers and so forth. Another important point to note is that there's no requirement for actual harm for the duty to have been breached. So you can see there it's about taking reasonable steps to eliminate risks or to minimise risks. So there doesn't have to be an actual event occur. If you have not taken all reasonable steps, then that is the offence itself. And also there's no requirement for causation. So I just wanted to reflect on a work health and safety, a recent case in Victoria that really illustrates how the work health and safety general duty to provide a safe system of work applies, and then think about how it's going to work in the environmental space, because it's as I've said, this provision, this new duty is modelled on that. So in 2016, there was a case involving a worker who was killed in a construction accident after falling from a piling machine that was not bolted together correctly. And the Victorian Court of Appeal held that the failure to include a warning in the manual about the risk of incorrectly bolting the machine and it collapsing was a breach of the general duty to maintain a safe system of work. And the court held that there was a risk that the machine collapsing and that was a risk to employee health and safety, including a warning in the manual was an identifiable measure that would have eliminated or reduced that risk, and it was reasonably practicable in the circumstances for the employer to include that warning. And there was a breach, or held to be a breach of that duty to maintain a safe system of work, despite the fact that had the warning been included in the manual, the accident would still have happened. So there doesn't need to be a causation between the accident that's happened and the failure, in this case, to warn of the risk, or the failure to reduce the risk. So you can see how that is going to play out in environmental issues. It means that all businesses need to really look at the particular activities that they are undertaking, undertake a risk assessment, and look at the kind of provisions that are reasonably practicable in terms of how those risks can be either eliminated or minimised. So for many, that's going to be business as usual, but I think for a good number of Victorian businesses, that's going to take a bit of rethinking. It means that you need to have environmental systems in place, you need to have them well documented. So we're working with clients, getting ready for those changes. The Act does provide some guidance about what is considered to be reasonably practicable, and you can see those on the slide there. Just wanted to draw your attention to the third bullet point there. So in a number of the provisions, there's a concept of imputed knowledge. So it's what the person knew or ought reasonably have known. So it's going to be important to be keeping up with industry standards, with industry best practice, because it won't be acceptable to say, well, I didn't know about this, or we didn't know there was that risk minimisation measure that we could have taken, if that's a fairly well-known industry practice or reflects industry best practice. So it also, as you'll see from the fourth bullet point, you don't have to minimise every risk. So economic factors, practical issues will be taken into account. So this slide is actually taken from a DELP presentation, although it's my photo, that just as some examples of the risk-based approach. So if, for example, you're in a low-risk industry, it may be that really simple measures are going to meet the general environmental duty. If you're in a medium risk, and they gave the example of a petrol station with an underground storage tank, there's very well-known risks. The measures to minimise and manage those risks are well known, and the EPA has guidance out on that. So complying with the EPA's guidance document, for example, would be a defence. If you're in a high-risk activity, then you need to have a bespoke environmental management system and be actively implementing it with all of the things that you would expect, with feedback loops and actual action taken. Another one of the new duties imposed by the new Act is in a couple of duties around contaminated land. So I thought these are actually ones that are causing the most consternation, and they will apply in the waste industry, but obviously more broadly. And to an extent, they really bring Victoria into line with other states. And in particular, there is a new positive duty to manage land and also a duty to notify. So we haven't had a duty to notify of contaminated land, but it has been in all EPA licence documents. So I think this one is quite interesting because it imposes a positive duty to manage the risks of harm to human health and the environment, again, so far as is reasonably practicable, on the person in management or control of contaminated land. So I think that is going to widen really the scope of those that need to be concerned about these issues. And the Act sets out what the type of things that are required. And as you'll see from the slide, it really is a matter of undertaking a risk assessment for the land that you own or manage or control. And again, this idea of what a person knows about the land and the contamination, or ought reasonably to know. So, for example, if you have land that has had various industrial activities undertaken on it over time, that is going to be enough of a trigger that you need to undertake some kind of inquiry. And the measures, if you find that the land is contaminated, the measures might include clean-up. So that is all without the EPA actually issuing any notices. These duties are now set out in the Act. And importantly, the duties also include providing adequate information to anybody who might be affected by the contamination. So that's clearly going to come into your documentation around the sale of land, any leasing or tenancy or other management of the land. It could also mean that there's a duty to notify adjacent landowners if there's any risk of migration of contamination. So they're quite significant and they're going to be backed up by a new public register. We don't have a very good register of contaminated land in Victoria, so there's been a lot of work done to produce a new register that will have a lot of data, so all of existing EPA data, emissions data, any notices, anything like that will all be coming up onto this new database. I wanted also just to call out site management orders. They're a new instrument under the Act that are specifically for the long-term management of contaminated land and will replace PCPANs for post-closure management of landfill, so post-closure pollution abatement notice. So I guess this is an example where the Act is really bringing the framework up to date and the enforcement options available to the EPA up to date, because a pollution abatement notice isn't really intended for the long-term management of contaminated land, but there wasn't really a specific tool available. They'll be registered on title and bind subsequent owners, and will obviously set out the kind of long-term management actions that are required, and you can see there the failure to comply is a fairly significant penalty. The polluter pays principles will be retained in the new Act and slightly extended, and there's quite a bit in this, but I think probably the take-home point is at the moment you really need a clean-up notice to be issued by the EPA before you have the right to recover the cost of complying with that notice if you're not the original polluter, whereas there won't be that requirement for an EPA notice under the new legislation. So there's quite a bit of talk that there'll be a significant spike in activity around people being required to comply with these new duties, then seeking to recover the costs from original polluters. There will also be a duty to notify of significant contamination with a relatively low trigger of $50,000 worth of investigation and remediation. So you can see that any land with any sort of contamination is probably going to trigger that. That duty will come in on the 1st of July 2020, so for those that have a property portfolio, it's worth really having a look into that, and then looking at the timing issues with regard to when you undertake clean-up, so as to be able to recover costs, because of course the recovery provisions will only start on the 1st of July 2020. Happy to chat about that if anyone has any questions. Because I want to get onto the waste management framework, and the general environmental duty provides the cornerstone of the waste framework, and also there are some really good provisions in there to clarify that the obligations and the duties apply right down the supply chain for industrial waste. So as I said, there'll be specific duties on the person depositing the waste, the person receiving the waste, so they'll be familiar to you. So you need to, there's a duty only to deposit at a site that's licensed to accept that kind of waste and that kind of thing. But interesting there, before a person in the management and control of waste relinquishes that waste, they must take all reasonable steps to ensure it will be transported to a place authorised to receive it and received at a place that is authorised to receive that type of waste. And that duty will include checking, identifying and classifying the waste, giving that information to the party transporting it so that they have enough information to take it to a relevantly authorised or licensed site, and also checking that the place where it is to be taken is appropriately licensed. So quite a significant duty on that person who is relinquishing control. And they're all offence provisions. And as I mentioned before, the EPA will have a choice of whether to take criminal prosecution or run a civil penalty case. How's my time going?
We've got 2 minutes to you, or in the last 2 minutes.
Okay, so I've got 4 minutes.
Yes.
Easy. So similarly, this slide probably should have been before the last one. So in terms of the categorisation of waste, we've got the general waste definition, which is similar to other states, being unwanted or surplus. Then we've got categories of industrial waste, where I had the definition up there. And then we'll have categories, a category called priority waste, which is the current prescribed industrial waste, plus some extras, and reportable priority waste. So in terms of priority waste, The key thing here is that it will cover the existing sort of idea of a prescribed industrial waste that's hazardous, but there is, as part of this idea, is the ability to classify something or prescribe something as a priority waste where there is a need to manage that for recycling or reuse purposes. So the priority waste will include not only the hazardous but the recycling type of activities. So there's a number of duties that sit around priority waste. One of those is a duty to investigate alternatives. So before that priority waste goes for treatment, there's a duty to investigate alternatives to waste disposal. And again, it's about reasonable steps. For example, assessing alternatives, reuse, recycling. If the person produced or generated that priority waste, how would they avoid producing or generating that waste next time? So it's quite a change and quite some additional measures that will need to be managed. Reportable priority waste is a further layer on top of the priority waste. So this is where you need tracking and transport licensing. And what the DELP has indicated is that if you have an offence against a waste provision or an industrial waste provision and it's a reportable priority waste, you could get the offences stack on top of each other. So you could actually face all of the offences going down the line if you have an offence in terms of reportable priority waste. That could also be an offence against the priority waste provisions and against the industrial waste provisions. So couple that with the fact that all of the enforcement the offences and the penalties have been doubled, and in the waste area for repeat offences, they can be doubled. So there are significant penalties up to about $3.2 million. So that is really bringing things, I guess, into light in terms of criticisms that the legislation just didn't provide enough in terms of penalties. Okay, so there's my time. I'll quickly let you just scan over the range of enforcement tools that the EPA will have at its disposal to allow it to undertake enforcement in undertaking a sort of a risk-based and proportionate response. I've mentioned penalties. There'll still be director and officer liability. We've got some extended chain of responsibility provisions allowing notices to be diverted to other members of the corporate group, for example. And as I've mentioned, implementation, we'll see the regulations come out later this year. So do get involved in the consultations with the EPA there. And there really, I think, is that there's a lot to get on top of. And as I've mentioned, there's a few duties that come into force on the 1st of July 2020 with regard to notifying of contaminated land and so forth that it might be well to be starting to think about if you have Victorian operations. Thank you.